Welcome back. So Numsa's legal woes continue. The union's two leaders, Irvin and Chirwa, could be charged with contempt of court after going ahead with the interdicted National Congress. The Congress was delayed after 31 members challenged their suspension in the Labour Court. Suspended member Ruth Ntlokotse has now filed a motion to have the leaders arrested. She joins us live now for more on this developing story. Ms. Ntlokotse, good morning, and thank you very much for your time. Now, we understand, according to reports, that you're forging ahead with legal action to have the court declare that the President and Secretary General acted in contempt of an order when they went ahead with that Congress. Can you firstly confirm that, yes, indeed, this is the case?
Good morning, Fundo, to your viewers and listeners, and thank you so much for inviting me. Yes, it is correct. We've approached the Labour Court and we filed the notice of motion challenging both the General Secretary and the President that they acted in contempt of court. It is correct that we did that.
And then take us back to days before the Congress. You were in court. There was then a ruling that the suspension should be lifted. It was lifted. What then was your expectation beyond the lifting of the suspension? Had you always thought that beyond that they need to then cancel or postpone the conference?
Okay. I think the judge has actually mentioned 3 areas that the union has to comply before they can convene a Congress. One issue, it was that to allow those who are suspended to participate in a Congress. And I must indicate, Mfundo, that that has never happened. We were not even invited to participate in that Congress. And we all know that we are all shop stewards, and being shop stewards, as and when the union requires us to participate in an activity, there has to be letters written to our employers to request for the time off. That it has never happened to all those 31. The only people who participated in that Congress are the people who are in the Western Cape. And then over and above that, there has to be travel arrangement made to all those delegates whom are expected to attend the Congress. That has never happened. And secondly, the court said, Mpumalanga region, they must be allowed to participate in the Congress. The local shop steward council must be allowed to elect their delegates. And we know that constitutionally it takes 10 days for a normal notice of a shop steward council to be convened where they will elect their delegate. That has never happened. And then lastly, the court said the Central Committee must elect the Credentials Committee so that all participants in that Congress, they must be accredited. What do we mean by accreditation? We mean that all the delegates to Congress, they must be shop steward in good standing. And we know that we are having a challenge currently where some of our members, they're active but are not paying subscriptions. In terms of the constitutions, those are not shop steward in good standing. And we also have members that are paying flat rate. And I can attest and tell you that some of those members were present in that Congress. And what the union did, they convened a central committee on Tuesday, and they just tick the box, especially when it comes to the credentials committee. The work was never done in ensuring that they are in line with what the court requires. Hence, we are saying that when we...
Yet we hear, apologies, Ms. Ntlokotse, yet we hear, or at least the position of the union has been that according to their legal counsel's interpretation of that judgment, the ruling did not prevent them from forging ahead with the conference, but ordered that the conference be held in line or in accordance with Numsa's constitution, which they felt that, in fact, as per the constitution, we fulfilled or ticked all the boxes like you say now. So you're saying that they misinterpreted here or they deliberately were in contempt?
I think they were deliberately in contempt. What I can tell you is that when you can look at the minutes of that Credentials Committee, it is confirmed in that Credentials Committee that Mpumalanga was not allowed to participate, which is something that is contrary to what the judge requires Numsa to do. And, Mfundo, I think it was deliberate for what the union leadership did and to the public, and including to the members of Numsa at large, because they know for sure that when the court was saying that Numsa, you need to follow your constitution to the letter, there was nowhere where the judge was saying that Numsa, they cannot convene the Congress. However, there were requirements that in order for you to convene a Congress, these are the areas that you need to do. And they know constitutionally that before they could convene a Congress, what is it that the Constitution requires them to do? So I think it was deliberate. The intention, it was to mislead the public, to portray themselves as if like they respect the rule of law, of which we know that what they did, they disrespected the rule of law. And I can tell you, Mfundo, that on Tuesday, after their central committee decided that they forge ahead, they are convening a Congress on Wednesday, they lost the leave to appeal in the Labour Court.
Yes.
And while the court has actually afforded a session that was 1800 hours in the evening, the Congress was proceeding. And they even went to an extent of electing amongst themselves. Hence, we are saying that Congress took place under the pretext of an interdict. The interdict, where the judge was very much clear that there are certain things that has to happen before the Congress could proceed.
But could you not confine that? Could you not confine that to interpretation of the law then? Because I remember my colleague, Aisha Ishmael, spoke to Phakamile Hlubi on that. And her understanding, at least from their legal counsel, was that the mere fact that they've now appealed means that order has been suspended so they could continue. So it sounded like it was an interpretation issue here more than deliberate contempt.
It was a deliberate contempt. Let me tell you why I'm also reiterating that it was deliberate attempt. During the court proceedings, the judge went to an extent of challenging their counsel that there's a misconception, a misperception that if a person has made an application, meaning that the prior judgment, it gets set aside. And he even went to an extent of saying that until such time, the higher court, which is the Labour Appeals Court in this regard, pronounced differently, that's when that decision will be set aside. But as things stand, he even went to an extent of saying that because of Numsa, he decided to proceed, let alone that there was an interdict and couldn't comply to what the earlier on judgment requires, that it was just an academic exercise. And we all know, I mean, we deal with so many cases as Numsa. Hence, I'm saying that it is a deliberate attempt. We've been involved in a number of litigations as a union, and they just did it deliberately so that they undermine what the code of law requires them to do.
Hopefully we can have them on to get their side of the story, what exactly happened. No, but certainly we'll try. We'll try to get them on hopefully tomorrow, anytime if they're willing to address this matter. But just tell me now, this conference cost 39 million. What would you like to see happen? Would you like for Numsa members to reconvene, have another conference to the tune of 39 million? Would this be virtual? What exactly are you seeking to achieve now?
Mfundo, a Congress is a parliament of workers, and it comes once every 4 years. And we know that as Numsa, we organize in various sectors. And this is a platform where workers in various sectors from different regions will come and make contributions as to how their policies, how policies should the union advance, either socio-economical or political, in order to improve their working conditions or even their conditions as citizens of this country. Should you not, or you deprive workers to participate in that platform? I think it's very much unfair. You cannot, being leaders, and decide who should participate in the Congress and who should not participate in the Congress against what the Constitution prescribes. Let's allow workers to participate in their workers' parliament. Let's allow the plant through their representative, who are the shop stewards, the locals, to elect everyone rather than us dictating, which is something that we saw towards this National Congress, where leaders would even go to an extent of dictating who should constitute part of being a delegate to the Congress. We are saying that this is very much unfair. And it cannot be correct that leaders of the union, they'll do as they please using workers' money, and at the end of the day, they'll come and advance that we cannot reconvene another Congress because of workers' money is being wasted. That Congress, it was not representing the views of all metal workers. It was representing a certain portion that the leaders of Numsa so decided that they must constitute the delegates of that Congress. Hence, we are saying that Numsa belongs to all of us. Numsa belongs to its members, to workers down there at the plant. Numsa does not belong to national office bearers of Numsa. Numsa does not belong to the Central Committee. It belongs to workers down there. Hence, Numsa believe in the principle of worker control, and which is one of the elements that we are no longer following.
So
I think we've seen that.
So I'm gathering what you're saying is that if the court rules in your favor, you must reconvene, you start all over again with that Congress.
That's what we are saying. We are saying that the Congress is workers' parliament. Let's allow everyone to participate in that Congress.
All right. Ms. Ntlokotse, thank you very much for your time.